Hi, everyone. Good morning, good afternoon. We have a large group joining us today, so we're going to give people a minute or two to log on and then we'll get started. Hi, everyone. Thanks for joining us today. We're going to get started in a minute or so, just giving people time to join. All right, we're going to get started as we have a lot of content to get through today. So thank you everyone for joining us for today's webinar, Conducting Fair and Compliant Workplace Investigations. We're recording today's session and we'll share it with you following the webinar. If you have any questions, please use the Q&A function on your Zoom panel. Now I'd like to hand it over to our moderator for today's session, HR Acuity's Chief People Officer, Rebecca Trotsky.
Thank you so much, Lexi, and I am delighted that I get to moderate today's webinar because it's always a fan favorite whenever we have Beth join us. I'm going to introduce Beth, but then I'm going to do a very brief overview of HR Acuity for anyone who is unfamiliar. Although I suspect many of you are familiar, you've probably been on webinars with Beth before because we always get lots of people whenever Beth joins us. So let me do a quick intro of Beth and then I'll take one step backwards. I'm very excited to welcome Beth. She's a licensed attorney specializing in labor and employment law with extensive experience conducting independent workplace investigations into harassment, discrimination, ethics breaches, you name it. She's a senior professional in human resources and has served as an expert witness on internal investigations and compliance matters. She sits on the board of directors for the Association of Workplace Investigators, AWI, and co-chairs the Grants and Charitable Giving Committee for the New Jersey Women Lawyers Association. And she always does just the best webinars. They're very interactive. We're really looking forward to all of the great questions she's going to pose so we can all learn. I learn something every time. It doesn't matter how experienced or not you are. We're going to all walk away with some great nuggets of learning today. And we can go to the next slide. I want to go through a little bit about HR Acuity quickly for those of you who are new to our community. We are a leader, the leader really, in anything having to do with employee relations. We provide technology solutions that cover anonymous reporting for employees to raise issues that are concerns to them in a way that's very employee friendly and welcoming so that you can really understand what's happening in your workforce and communicate with them back and forth anonymously. We offer a very easy way to document anything that's happening related to employee relations, any concerns or out of the ordinary events that occur. We also offer best practice investigations, technology, case management that helps you ensure that you are protecting your organizations and making your workplaces safer at the same time. And then we also offer really great analytics that help you track what's happening in your organization so that you can be more proactive and continue to make it a safe and great place to work. If you're interested in learning about what we do or what we offer, how we could support your organizations, please come to one of our demos. We do curiosity tours. You can reach out to us and we'd be happy to show you. You can go to the next slide. In addition to all of our great technology and software solutions, we are obsessed with employee relations. So we do all kinds of studies and we offer lots of resources for anyone in our community who wants to improve what you're doing in your organizations. We have an employee relations benchmark study. Many of your organizations have likely participated. We have a new one that's coming out in May, I believe, that will highlight everything that happened last year, and look for that. We will do a webinar on that. We also offer our employee relations quotient, which is our maturity model that offers really practical steps, no matter where you are in your employee relations journey, for how you can take very simple steps to improve and make things more consistent and transparent in your organizations. And best of all, we have our great community. So you're all part of the community. We offer Empower, which is our online community of HR and employee relations practitioners. Please do join. If you only do one thing today, join that community. There's a great conversation going on there all the time. You can ask questions and get support. Sometimes it can be lonely when you're in employee relations, and this is really where you will find your tribe to offer you ideas and share best practices. And then we also have our roundtable, which is comprised of leaders in the space who get together in person once a year. And then we also do, connections through our Empower platform. So we are definitely going to be sharing lots of information about upcoming events in Empower and the roundtable that's coming up at the end of October. And it's going to be in Boston this year. So, and feel free to take the poll and share how you would like to learn more about us. We can go to the next slide. Okay, so mark your calendars. I just mentioned it, but we do have our roundtable coming up in Boston. That's not until the end of September, but you can register. So we would love for you to join us for that. And we have a couple of great webinars or events that are happening in our Empower platform in our community. So the webinar is on April 23rd, and this one is all about what's happening in the space of DE&I. How can we navigate it? How do we make sense of it? So be sure to join us for that. Jonathan Hyman is going to be hosting that. And then we also have in Empower a conversation with a couple of our leaders in the space discussing how to strengthen cross-functional partnerships in employee relations. So that one is going to be really good. It's a crucial skill for all of us in HR and ER. So mark your calendars and be sure to join. All right, one more slide, and then so without, I love being able to share these things. We always ask our presenters or our moderators of our webinars to share a nonprofit or a charity that they would like to support, and we always make a donation after the webinars. And so for this one, Beth has selected the No Limits Cafe. We have supported them in the past, and I love it. They train and employ adults with intellectual disabilities, and the mission is to empower adults living with intellectual disabilities by providing jobs and job training, and really be a part of their community, which they are. So it's a great one that we love supporting. So, and I think that is it. Without further ado, I think it's time for Beth.
Okay. Hi there. Nice to be here. I love this community. Thanks so much for that very, very sweet, wonderful introduction, Rebecca. I appreciate it. I just want to give another shout out here to No Limits Cafe. Actually, the founder of No Limits Cafe is a college friend of mine. She actually had has a child with Down syndrome and started this cafe about 15 years ago or so, and it is just wonderful, the work they do. And actually, just to let everybody know that it is they've been invited to bring their food truck to Lincoln Center in New York City for this big umbrella festival, April 5th through 6th, as well as April 12th through 13th. And this festival celebrates inclusivity with sensory-friendly performances, activities, highlighting the talents of neurodiverse artists and audiences.
Wow, maybe we can
Any of you
include a
are
link in
listeners-
our follow-up.
This is
If you have
great.
information, send it to us and we'll put it in our follow-up for anybody who's in the New York area. That sounds amazing and something like we really need that right now.
I agree. I really agree. And I'm really excited. And I just wanted to shout that out, and I will send that information on. So just a word or two about me and my firm. Tribute Partners, single focused is workplace investigations, all things workplace investigations. We believe that an independent, well-done investigation helps an organization and employer make informed decisions, of course, minimize legal risk, but build resilient workplaces. And that's really where we come from. You should come from a place of building resilient workplaces and helping organizations be able to make decisions that are informed based on facts. What we also do is, in addition to our workplace investigations, is we do some post-investigation work for employers who have conducted investigations either by other people or internally, and we can help rebuild a team or do some coaching to help remediate issues or repair processes that were discovered during a workplace investigation, so that there can be information that can be gleaned from a workplace investigation that can in turn then create some powerful changes within an organization. Through Tribune Inside, what we do is we go in and we can audit internal investigation processes within an organization, help recommend as consultants some changes, and help implement that by writing new policies and processes or tightening up ones that an organization has, and then training investigators and having some post-training services available to help implement those changes. So as I said, we do everything workplace investigations because it's the world we live in, and I actually believe in it very, very much. So today we're going to be talking about what is a compliant workplace investigation. And I don't use the word best practices because there really isn't such a thing as best practices. There are standards that are customary. There are standards that are effective, that allow an employer to be informed, that are adequate. And we'll hear about that a little bit. That's what the EEOC also refers to, an adequate or an effective investigation. So there's a lot of confusion around, well, how do we know that our investigations are compliant, and how are they judged later on if they're tested either by an employee, a leader, or later on in court. And really it harkens back to an impartial, prompt, thorough investigation. And we'll talk about what are the skills and the tools that we know and that we've learned, and the resources that we can use to better understand what it means for an investigation to be adequate. I'm also going to talk about a few thorny issues that can get in the way of conducting inadequate investigations, questions that people often ask me about. I thought we'd have a little bit of discussion and talk about it through here. How we make tough calls and make findings. We always are worried about credibility and how to assess credibility. So of course, I'm going to talk a little bit about that, and striving for consistency. Also, just to go back, I added some slides at the end about communication and communication of results of investigations afterwards. Not sure we're going to have time to get to it, but it can always be another program because I think it's something people are always wanting to know more about. So I recently facilitated an advanced investigators seminar or series in LA. I'm mentioning this before when we were on the call earlier. And one of the co-facilitators was talking about DE&I, and what she brought up was, I think we need to call out the elephant in the room. There's a lot of confusion and concern over what DE&I looks like, what it's going to look like, and what this means for our workplace investigations in particular. I think it's important to remember that equal employment and anti-discrimination laws and their protections are enshrined in the U.S. Constitution and in our federal civil rights laws, and an executive order cannot change that. but it is our reality, and what that means to us as workplace investigators, whether we're external, internal, ER, or HR, I think there are going to be some things that are worth calling out. On April 29th, 2024, the EEOC issued guidance on, wait, I want to just go back a slide, I'm sorry, there. On March 19th, 2025, the EEOC issued guidance that it calls DEI-related discrimination. And what it says is that it reinforces the Title VII protections that I just referred to. But what it also does is it recognizes and states that there are two technical assistance documents. One is what to do if you experience discrimination related to DE&I at work, and another one, what you should know about DEI-related discrimination. And it refers to, one of the things that it specifically states is, depending on the facts, DEI training may give rise to a colorable hostile work environment claim. So the training itself could give rise. And another statement that it makes with regard to retaliation is, reasonable opposition to DEI training may constitute protected activity if the employee provides a fact-specific basis for his or her belief that training violates Title VII. Now, I know you at HR Acuity are going, you've got somebody who's going to be speaking about DEI, and I think that's wonderful. I think it was worth mentioning for us with investigators is what that might do for us. Is this going to signal, is there going to be a fundamental shift? I think it's not a fundamental shift in what constitutes a good workplace investigation. But I was noticing that actually Deb Mueller commented in a LinkedIn post recently, some observations that she made that I couldn't agree more with. And that is, there will likely be more claims, and there will likely be even more heightened scrutiny, and there is more of a need for consistency in showing our hard work in the process than ever. So
that's why I'm glad we have you on today. This is perfect timing because we need to keep that consistency regardless what's happening in the world.
Absolutely.
So good timing for you to be here.
Yeah. So what are fair and compliant workplace investigations? Well, let's get started with the basics. And I refer to the EEOC, they've got lots and lots of guidance. I'm happy to provide links to some of the guidance that I'm going to refer to today and other information that's out there afterwards. If anybody wants to reach out to me, I'm happy to provide links. But where we get the information that I'm going to talk about is from the EEOC. They've published the guidance that I just mentioned, as well as it refers to promising practices that were promulgated after the task force came out with its recommendations. So there's a lot of great information out there for employers. SHRM, of course, also has that information. I know HR Acuity, AWI, Association of Workplace Investigators, has lots of information, webinars, seminars, as well as institutes. So there is information out there by people who are conducting it and doing it. And then from either your state civil rights or the federal EEOC has all this information. But everything is consistent on this. Once an employer has notice of any potentially harassing conduct, it is responsible for taking reasonable corrective action to prevent the conduct from continuing. And this includes a prompt and adequate investigation and taking appropriate action based on the findings of that investigation. So there's a couple of things here that are really important. And one is, what is notice and what is potentially harassing? The EEOC has made it clear that we're not just talking about sexual harassment. It can be harassment based on any protected characteristic or somebody who, if it's based on, as we now know from the technical guidance that was just published last month from the EEOC. So once an employer has notice, what is notice? I want to just talk a little bit about that. Well, an employer has constructive notice, and that means should know. If under the circumstances presented, a reasonable person would know about the conduct. So I'm gonna move over. Let's move on. There's an example I have here, and we're going to talk a little bit about this, Rebecca. I think this is interesting and something that we see. We've got an intern in the marketing department. She has lunch with another associate and their supervisor. She asks if they think that their manager or the manager can be creepy, but she doesn't say much more. Does this constitute notice? Rebecca, in your experience, as I know you were internal.
We have a lot of yeses coming in on the chat, and when I
Okay, 'cause
saw
can't
this in
see the
advance, I
chat.
was like,
Thank you.
yeah, the word creepy seems like that would be a trigger.
It does. It sounds like it's a trigger. Now, is this a trigger? This is a trigger that there's something going on. The word creepy it kind of raises our suspicions a bit there. We want to know a little more. The supervisor is sitting there with her at lunch. Does the supervisor have an obligation? At this point, I would say yes. What is that obligation? The obligation would be to advise this intern about her or his or her options in terms of reporting a complaint, whether it be ER, HR, any other places, avenues of complaint. Supervisor may want to explore a little bit more. Can you tell me a little bit more about that? This person may be more comfortable with the supervisor, with this other associate sitting there, giving a little bit more information so that supervisor can help, after getting that trust, explore with this person about what we're talking about. I'm not suggesting that the supervisor start an investigation. Supervisor should never investigate, but the supervisor usually has, under most companies' policy, an obligation at this point to do something. And if that intern doesn't want to report it, the supervisor should report it, because this could constitute constructive notice to the employer.
Yeah, and we have lots of people chiming in, reiterating this in the chat, enough to get more details, tell me more, learn more about the situation. So yeah.
Absolutely. So give me a little more, tell me more, get some more information so that you know what we're talking about, but don't start an investigation. And I think it's really important, because if you just say, oh, you should call the hotline, very likely this intern won't. So you want to spend a little time to make sure that this intern has a comfort. You build a little rapport so that they understand and trust, and even offer that if you want, you can make that introduction. If you're you're not at a virtual workplace, and you can, walk that person down. I can't see the chat, so if you wouldn't mind just letting me know if there are questions that come up. So
yeah, we have
okay.
a question around the documentation, like should the supervisor email information to the intern to document that they had a conversation?
So, I mean, I think that isn't a bad idea. I don't know if it's necessary, but I think it's certainly a good idea. If you're worried that later on this intern may file a complaint and say that they never knew. So that's really, I mean, documentation is always important. The way you word it is going to be important. So you don't put the person off, so it doesn't look like a legalistic type of document, depending on how you would word it. But yes, and I think that that's a really good, I like that idea. And also whether you'd copy somebody else in it or not. Yeah, I'm introducing you here. We mentioned at lunch, I'm introducing you here to Rebecca. Rebecca would be a really good person for you to continue this discussion with. So it's reasonable. And when do you start an investigation? So you've got notice, constructive notice, and it doesn't have to be, there's no magic words. You're not, I'm going in to make a complaint. It sounds like everybody here on this call recognizes that it doesn't have to be a formal complaint. It can be something informal. It can be an intern, even an unpaid intern. Once you have some sort of notice, the supervisor has some sort of notice, there is an obligation then to do something promptly. Well, what is a prompt investigation? And this is a place where people also, I think there's a lot of conversation about what is prompt. And there's a lot of concern about, oh my gosh, we need to get this started right away. Can you start your interviews? It's in the EEOC and in their guidance has a lot of information in their footnotes where they discuss actually court cases where what has been considered prompt and what has not been considered prompt. So I would welcome people to look at that if they want more information about this. But I think what they're referring to with prompt is opening an investigation. It doesn't mean jumping on and making that first witness interview call. It's about opening your investigation and getting started. Because as we know, there are things that come up that get in the way of starting that investigation right away. And I've talked about planning before because I think planning is such an important part. You need to understand, of course, what the scope of the investigation is, look at people's schedules, pull out their appropriate policy, do any of that information. So that is considered starting your investigation. And I always think it's important to document that you're doing those things to start it, because that will count towards your prompt reaction. So sometimes there are other things that happen, and I see all of these things often. So you're ready to start. And as soon as you get this complaint, you're looking into people's schedules and you see that the subject is scheduled to attend a critical client meeting out of the country and is unavailable for 10 days. And maybe in this particular case, you really want to meet this person in person anyway, but you're hearing from the leadership team that this is not going to happen. I'm sure I'm not the first person who has seen this in an investigation. I think before there's any panic that sets in about the promptness and whether or not this is enough time, I think it's important to step back and take a look at the allegations. Is it a sexual harassment? Is it some sort of physical allegations of physical misconduct or abuse? In that case, you do want to stop and think about, all right, we need to have, maybe this person doesn't go on this client meeting, depending on the nature of the allegations. But if the allegations are about retaliation or a performance evaluation that the person thinks is discriminatory, which is a lot of what we see, maybe this isn't such a terrible thing. You're going to start getting your documentation and meet with your witness interviews, your reporter or your complainant and some other witnesses, and maybe be getting some comparators. So this 10 days doesn't preclude you from getting started. And in some cases, this subject being out of the country for 10 days is going to be on your side, because you want to be conducting witness interviews where maybe there isn't any threat of intimidation or concerns about retaliation during the course of the investigation. So it's a good thing that this person, what you want to do is document these things though, because I have this under prompt, because these are the things that if they're happening, any of these items are happening, you're going to document them, but it doesn't mean you can't continue. I've had cases where the reporter wants to talk with his or her lawyer first. So you're ready to start, and then you hear they've got a family friend that's a lawyer or a lawyer that they want to speak to first. Depending on the company's policy, I don't think you could ever prevent somebody, no matter what your policy is. I mean, sometimes there are employers that say, I don't want this lawyer present during the interview, and that's another topic. But if the person says, look, I'm not ready to speak, I want to talk to a lawyer first, I would suggest you allow that to happen. Anything that makes your process look that you are trying to get the information in a very fair manner is going to be helpful to show a fair, thorough investigation later on.
We have a lot of discussion around SLAs for investigations in the chat, and so they're varying greatly, but I think your point around it depends on the nature and the complexity of that particular case, and your point around at least get it started, get documented what you're going to do, have your plan. All of these things are what matter, but I see lots of chatter around how long SLAs are.
Let's see that, and that always is, and I understand that pressure. And I think when you have this documentation later on, it helps inform what our metrics are later, and why the timing is what it is. Anything that's documented, anything that slows it down, it is not necessarily a bad thing if it helps your fair, thorough process, because at the end of the day, that's more important than getting that interview scheduled right away. And all of these are reasons that are not critical, but will and could impact fairness.
Yeah, we did have one call out for our benchmark study, which does do investigation timelines in the benchmark. So look for that, or you can go download the most recent one from our website. But thanks.
Yeah, I often refer to that to clients because people are always asking this question. So I was glad to see that in your benchmark survey. And sometimes you start conducting an investigation, you speak to the reporter and you learn that the HRBP isn't the right person to conduct this investigation, and that might slow it down. So to have a policy in place, some sort of recusal process, some sort of policy that you can revert to keep the investigation moving along is going to be helpful. Referring to an outside investigator also sometimes takes a little time. Finding the right person, finding the person with enough time. As long as you're documenting it, usually there's a reason for it. It's either high level or egregious circumstances. And in that case, you want to make sure you've got a subject matter expert. It goes then to the impartiality and the thoroughness. So these are all the important parts, is the not just prompt, but impartial and thorough and fair. And those impartial, thorough, and fair, I say trump the prompt. When you understand that prompt means you're opening your investigation and you're getting it started. There's a lot of work that you can be doing before you're starting those witness interviews. And so the EEOC speaks to reasonable corrective action. What do you do when you hear about harassment? Well, an adequate investigation, and that's really what I wanted to talk a little bit more about today, is what is an adequate investigation? And the EEOC says, well, it's adequate if it's sufficiently thorough enough to arrive at a reasonably fair estimate of truth. And so we'll talk a little bit about what that means. An impartial party, it should be conducting your investigation. Somebody who had nothing to do with the decision and the outcome doesn't matter to them. It doesn't matter that they're not invested in the outcome, and they weren't involved in any of the circumstances giving rise to the allegations or the complaint. And the investigator should seek information about the conduct from all parties, speak to both the reporter, the complainant, and the subject, of course. And I'm referring to reporter and complainant interchangeably. There is a shift right now in this field where we're starting to call the complainant a reporter rather than a complainant, because they're reporting conduct, and it is less there's less stigma associated with the word reporter. So some organizations may have started using that. I'm seeing that a little bit more. The EEOC and their promising practices as well states that the person who's conducted the investigation should be well trained in interview skills. We're going to talk about that in the next few slides about what are some good interview skills. But again, I want to shout out to SHRM, EEOC, AWI, your state civil rights office. They all have, usually, most of them have free webinars available to help with training on interview skills, especially AWI has a lot on that. And the membership price isn't really expensive, and it includes all the webinars and seminars. The investigator should be well trained, not just on the skills for how to interview in a manner that's objective, but how do you determine and evaluate credibility? Because nearly all the time, you will be assessing credibility to reach your findings, especially if there's conflicting versions of relevant events. One person says one thing and the other person says something else. Of course, you're going to make credibility assessments, but you're always making credibility assessments throughout an investigation as you're determining what's important and whose assessment of what happened or report of what happened is more reliable. Okay. Right, so here's another a place that we can have a little bit of a discussion here. Oh, this is a older version of this. This should say HRBP, not HRPS. Your organization has an HRBP investigating employee complaints. The reporter or complainant alleges that a performance evaluation was unfair and in retaliation for a complaint that he had made about reverse discrimination. The HRBP reviewed the performance evaluation before it was finalized. In this case, and Rebecca, I know that you did investigations before internally, as I think you said an HRBP, right?
Oh, yes.
And so in this case, would you have been asked or tasked with the investigation?
Probably, but
Yeah.
I would likely have asked a peer to step in. If I had been involved in the performance evaluation with this individual, for sure, ask somebody else to do it for me.
Yeah, and you know, that's right. Now, every organization isn't set up that way. It depends on the size of the organization, right? And so wouldn't that be nice if you don't ever have to do or conduct those investigations? So in the case where you unfortunately have to conduct that investigation, which really isn't the best case, like when I do expert witness work, that would be one of the biggest vulnerabilities in this type of in this particular investigation, because you've got an investigator who's supposedly objective about a decision that they signed off on. And that's just very difficult for somebody to believe that they could be. But it happens, and sometimes you have to be. So for an employer to maybe build in processes, even if they're not formal processes, but again, either a recusal process that if I feel that I can't be fair and objective, Rebecca is going to conduct those investigations. And likewise, when Rebecca has that concern, I will do it. So that's an easy workaround where I think that is something that could be done with an organization. Or you tag team where somebody makes the actual factual findings and somebody else makes the determination of whether there was any violation of policy. Or you have a peer edit, a review of your findings, or you have regular team meetings, your HRBPs where they meet to discuss their investigations and their findings, to have some sounding board about what the findings are and where there could be some weaknesses or vulnerabilities.
Right. As long as you have a process that you can demonstrate is sincerely, trying to find the best answer in the most objective, impartial way.
Yeah.
We did have a question, like, is that the recommendation for HRBPs to just not be involved in these kinds of investigations since they are integrated with client groups?
That would be my recommendation, absolutely.
Yeah.
But I understand that it's not always possible.
It's not
So
always possible, right?
If it isn't, then just have something set up, even informally, that you've got somebody looking at it, because you will be questioned. If it doesn't go to litigation, and we're not talking about deposition, you've got even your employees wondering. So you want to make sure, or the leader, somebody will be asking.
Yeah.
And I think you owe it really to the process, right? And
Yeah.
to everybody.
Like when I was in this position, I just had my opening protocols, which of course we recommend as well, where I would say this part of my role is to do this. I've been trained, I have a process, and I commit that I will be fair and impartial, and I would ask, like, do you believe that I can do that? Right. Just to get that confirmation in absence of being able to have somebody else do it.
I think that's a really good point. A really good point. I think that building rapport in the beginning and being transparent, and like I said before, calling the elephant in the room when we started talking about this discussion. But even saying to somebody, look, I understand how this might feel. Let's talk about that. I do that when I'm doing my retaliation, the retaliation instructions in the beginning. If I see that somebody's struggling, we stop and we talk about it, and I ask them to help me understand what their concerns are so that we can speak to them a little bit more. So transparency is always your friend, because we can't always have these perfect policies in place. And same with, okay, so if you, and this is another thing that happens very often where there's a witness who's critical to your analysis and findings and they're no longer employed. Do you reach out to a former employee and interview them in a current investigation when it is a important witness? Again, I think that you have to look at your employer policies. Sometimes we're stuck with them. I think that if it's a critical witness, it's always best to be able to interview them, but that's not always possible for a lot of reasons. So then there's other ways to sometimes determine credibility or to understand the facts, and you just keep looking. You just don't say, I can't. So I think with this, as well as some of the other circumstances and scenarios that I just mentioned, there are things that get in the way of being prompt, but we can keep moving it along, understanding and acknowledging some of the issues and thinking ahead about them. So being a skilled interviewer or an investigator when you conduct investigations, we've already alluded to some of them. That's that introduction, instruction, where you're explaining the process, what your role is, taking that time to build trust in you and in the process, listening actively to questions that the witness may have. This is all part of, we call rapport building, but it's building transparency and trust in your process. And when we're always thinking about the prompt investigation and timeliness because of the pressure we feel we're under, sometimes we skip over these things and hurry along to start asking the questions, especially when you're internal and you may already know the person. It's always very good to just step back and think, this is a witness, this is somebody who's got a concern or who doesn't want to be involved. I want to make sure that they understand this process, how I'm going to be using the information I learn, and what's going to be happen later, and to answer questions. It's a very important part of being able then to obtain information, especially some of the difficult details that are going to sometimes follow with your questions. Ask questions in an open-ended manner, and not suggesting an answer. So asking it in a way, can you tell me about this is the sort of thing I hear all the time. I'll ask people what their concerns are. My boss is harassing me. Well, can you help me understand what that means and what that looks like? Well, he or she is dismissive and disrespectful to me in meetings. My boss is a micromanager. He's harassing me. He gaslights or she gaslights me. It's her or his tone. That's not giving you any information. That's giving you some characterization of some information that they think constitutes harassment. So then taking their words, you said he's dismissive. Can you tell me what that looks like? The person may say, well, when I start to answer a question, he cuts me off quickly and won't listen to the answer. When's the last time that happened? Can you tell me more about it? Who was there? Who else would have seen it? Have you seen him do this with other people? If so, with whom? So using their words and starting off, they're going to answer generally, and then specifically asking, listening, and repeating back their answer for them to keep giving you the details. And so that's what is often called the tunnel method. You start broad, and then you keep getting more specific. Going back to, you said it was at a meeting. When was that meeting? What I also like to get is if somebody says it happened at a meeting and there's going to be an issue about whether there were other people there or whether it was one-on-one or the date of that meeting, because the timeline is important with retaliation. Get the calendar invite, get the Zoom notes, get whatever you can, because that's going to help later on when you're making credibility assessments.
We have a couple of questions.
Sure.
One related to the witness that you mentioned who no longer works for the organization. Do you take any extra steps to ensure that there's confidentiality there, or how would you approach that?
Oh, so extra steps to ensure confidentiality. Oh, so that witness doesn't talk about it.
Right.
You know, I think it would go back to what we were talking about earlier, acknowledging that that is a concern,
Yep.
bringing it up, discussing it. You know, if this is an executive, you're going, hopefully that conversation, because if we're talking about a decision maker here, an important decision maker, they'll understand, but you want to remind them about professionalism and confidentiality.
Right.
And how important it is to the integrity of this process and respect for everybody involved in the process. So again, reiterating those things, and I think that's the best way to
Yeah.
handle
And
that.
sticking to your process. I mean, you would do that with witnesses anyway.
Anyway, just, yep.
A couple of questions, and you might be coming to this, but specifically related to interviewing the subject. How specific do you get with what the allegation is? And how do you kind of close out that conversation?
So, you know, it depends on where in the process we're talking about. So if it's that introduction email or call to that person, telling them that they are the subject of an investigation or a subject of an allegation or a complaint, you'll very rarely, would I recommend you give a whole lot of detail there. Now, this is jurisdiction. I know in Canada, you have to give them like a letter of particulars where there is more information ahead of time. So outside of, I don't know of any US unless we're talking public sector, but let's just talk about for most private sector employers in US. I would say my recommendation is you don't provide a lot. You say that there's some information, a concern that's been raised about some conduct of yours that may give rise to a policy, a violation or issue. You'll learn more about it when you meet with the person who's conducting the investigation. As the investigator, when I start in that introduction instructions, I give the same introduction, you know, this is what I'm here to do. What it does is it allows everybody to calm down a little bit. Depending on the subject and the level of anxiety, you may need to cut right to the chase and say, okay, I understand and I see that you're concerned. Sometimes they'll tell you that right away. I'm going to let you know what this is about because I really, really want to hear what you have to say about all of this. And I want to make sure we have the space and the time so that you can provide that. I have not made any judgments or findings yet. And this is what this is all about. The interviews. Sometimes I'm calling them meetings and not interviews. Sometimes I'm not calling them witnesses. I'm calling them employees. Anything that helps just bring down the anxiety and stress level associated with it. So I will say to the person, you will know what this is about. By the end, we will talk through it. You're going to have every opportunity to hear more as we go along. So that's usually what I say. I don't say it right up front. Sometimes, though, I have to. Really, it depends on the witness. And if that's what they're going to need to be able to just sit and be able to participate in a manner that I'm going to be able to obtain the information, I will tell them in the beginning.
Okay, great.
So that last bullet, show up where they are at. You know, I did trauma-informed interview training last week, and that's what I was talking about there. And I think that equally applies to everything. And I think it answers the question you just asked me. You know, you really listen, understand that our objective here is not to trick anybody, or it's not a gotcha moment. It's about hearing and learning what they have to say and giving them a full opportunity to be able to provide their version of the event.
We have a couple more questions around confidentiality, like if they blatantly just go talk about it, what can you do? Another couple of questions around, you know, we can't really enforce confidentiality because then you're running up against NLRB prohibitions against concerted activity. Thoughts about all that?
Yeah. I mean, and that keeps waffling back and forth depending on the administration and the NLRB. Right now, what I'm saying is I'm going to ask that during the course of this investigation, you not talk to other people, tell other people the questions that I've asked you, or discuss with them what they should say. Like, I really want to be able to understand from every single person what they remember. I talk about the science of memory and that it's malleable and that we don't have an imprint in our mind from when we saw or we were present, and that when we talk about it, it imprints over our memories. So I give a lot of that about why it is. And by the end, they're nodding and they agree. Doesn't mean they're not all going to go talk about it. And I don't ever say you cannot, there's no, you're prevented from. But I strongly suggest, and I'm seeing more and more employers are requiring confidentiality because they'd rather have a process that's working and fair. But I still think I'm not requesting confidentiality. I'm saying it just the way I did. And people are going to talk or they're not going to talk.
Right.
Right.
The other angle is it's a big distraction on a team. And so to keep the drama and distractions to a minimum, that's another.
Yeah, that's another really good one.
People can relate to that. Like they just want to come to work and do their work, usually.
I say that, yep, I love that. I say that to people. And I'll say, people just want to come to work. I also say, you might be on any side of this one day. You may be the subject or to a witness, you may need this, you may need to avail yourself of this process. Just think about how you'd like to be treated. Just think about that. So again, really at the end of the day, we're all here as adults, we're here professionals, and this is a process that's as good as you all make it, right? This is your process. So those types of conversations are really helpful when it comes to the confidentiality instruction. So you interview the reporter or the complainant, and you're ready to start interviews of, okay, you know who the subject is, who ahead of time who the witnesses were. You knew that going into this. What I always like to say is wait to schedule all your witness interviews until after you've had that complainant interview. Don't think, okay, I know who this is about, and I know who probably is likely going to be the witnesses, so I'm going to start reaching out to them, because they may not be. Now you've reached out to them, and it's very difficult then to say, okay, never mind, I don't need you. It may be somebody different than you thought it would be. So after the complainant interview, you want to organize your notes, look to see what you had, understand, okay, what was the complaint? Is the complaint still the same? Is it different? Is it broader? Is the scope going to need to change or not? Look at your witness list, look at your policy, look at what information you're going to need to be able to show whether or not there was a policy violation or breach. And in that case, make sure you're getting that information. You're going to determine your order of witnesses by looking at people's schedules. Is anybody out on a leave? So you want to stop. Even though we're talking about prompt, we're talking about a thorough, independent investigation, and one that you can keep getting that doesn't start getting into a scope that isn't consistent with what you originally were setting out to do, which often happens if we're not careful to sit back and revisit the scope after the witness interview. So one of the things I alluded to earlier is the conflict when there's no eyewitness. And you've got what used to be referred to as a he said, she said. There's a lot of different terms used now, but she said, he said, she said, different conflicting recitations or memory recall. We have to remember our analytical standard here is a preponderance of the evidence. Did it more likely than not occur, or whether it was more likely or not that it occurred, greater than a 50% chance. We do not have a clear and compelling evidence standard. We do not have to know for sure that it happened. We need to know that it more likely than not happened. And the reason, and we're not thinking, oh, well, I believe her more than him because she cried or she seemed upset. You want to make sure that we are assessing credibility through appropriate, well-recognized techniques. And I'm going to move along past our own credibility, such as confirmation bias, and there's a lot of other biases. It's a whole nother great seminar or webinar we could do on credibility alone. Confirmation bias is one that's worth calling out here. It's when you think you're halfway through and you figured it out, And now you start looking for information, either the way you gather it, the questions that you ask, or how you interpret information you receive that is consistent with what you thought it was going to be. And make sure that we're not doing that. And how do we make sure we're not doing that? By either having somebody else read our reports or review them, having our team meetings where we're touching base and testing our findings with others to make sure that we're not, and that we're relying on real credibility factors as we evaluate witnesses and information that we gather. Is there corroboration? Is there anybody else who had a consistent version of events? Yes, 2 other people were in that meeting. They both reported it to have happened more similar to what the reporter said or the complainant said than the subject. Then you also want to look at the reliability of that witness. Is this person somebody who really could see it, hear it? Was it a Zoom? Were they on the Zoom, even though it shows that they were on the calendar call? Is this something that somebody told them afterwards? How reliable is that information? Is this somebody's best friend? You want to make sure that you evaluate those things as well. And you want to look for information that's consistent with the party's testimony. So there are other credibility factors. And again, credibility is, I could spend 3 hours on credibility, and I have. So I am flying through credibility, but it is important that we be trained as investigators on an independent investigation. And when we look at what is impartiality and a thorough process, it's making findings where we are doing our hard work and we're assessing the information we learn objectively. This is putting up guardrails to make sure that we aren't entering the picture with our own impressions, because that's what makes investigators vulnerable to attack about their bias. So these are credibility factors that are good to use. Is this plausible? Does it make sense? Often this is with timing. There's no way this could have happened that fast. I've seen this, like if it's an offsite party and somebody says they got back to the hotel at such and such a time, and there's no possible way because it's 10 miles and they said they got there in a minute. Motive to falsify. This is something people use a lot. He has a motive to falsify because he's the subject, but then everybody would always say they have a motive to falsify. I would say I use it more if a witness who corroborates something doesn't have a motive to falsify. There's no reason that this person would make this up. Material omission, but you have to be a little bit beware, because sometimes, like in material omission, if it's a trauma-informed interview and you're talking to somebody who's suffered a trauma, just because something was omitted doesn't mean they're lying. So you want to make sure you're thorough and you keep digging. These are the credibility factors that I recommend you proceed with caution. Reputation, that's a difficult one, and one that I don't think holds up alone. You need to have more than a reputation. Attitude, again, people have, we talk about neurodiversity and how people show up and how we all respond and cultural differences. So attitude, unless they changed when they answered certain questions, but attitude, well, I would expect that they would have cried if they were upset, or I would have expected him or her to feel more sorry and they didn't, or whatever it is. If you're looking at attitude, that is always I would say a red flag if you're using that for your credibility factor, and that's the only thing you're using. Same with demeanor. I don't ever use demeanor. I don't have any training in demeanor. There's a lot of good people, good liars out there. So I don't like or use demeanor, and I see we are just about at the end here, so I'm going to keep going here because I do want to talk about consistency. We've talked about this, making sure we have written protocols, we have training, audit and review. I can't tell you how strongly I recommend that at the end of the year, you have somebody review a sampling of your reports to make sure that they're consistent, not just in terms of how they're written, but their findings and how your policies are applied. So I am going to stop there.
Yes.
I know we have a minute.
We have 1 minute, so I apologize. There's no way we can get to all the questions, but the community in the chat has been great at supporting each other. And we could continue in Empower and have a follow-up to get some more of the questions answered. But just maybe one really quick, can you just reiterate or say more about why you recommend starting with sharing fewer details on the allegation at first? Apparently their team is having a debate about, do they go in with the allegations to the subject, or, as you said, go more vague?
I like to start off by building rapport, because I think it builds somebody's comfort, and before you start getting to those difficult questions where they know right away what this is about, you're not going to, for me personally, I don't think you can get that same level of information. And sometimes you've got somebody who's trying to figure out what you're going to say, and they're not giving, it's harder to evaluate credibility. It's my style. What I like is to get there. But like I said, when I answered that question earlier, if this is going to prevent this interview from going well, absolutely, I would tell them what the details are. There's no hard and fast rule there. I think either way can work as long as you're doing it consistently.
Right. Well, Beth, as always, lots of great information. Everybody's very appreciative of this. I do think we need a follow-up. We've already had a couple requests in the chat for additional follow-up. So perhaps in Empower, everybody join Empower and keep the conversation going. I can see you all support each other and have a lot to share. Lots of wisdom.
Oh, great. This was fun. And I would love to be something a little more interactive, because I always learn too every time I do these.
All right. Well, stay tuned, everyone.
Thank you.
Everyone.
Okay, bye-bye.
All right. See you next time.